With the other side, I am like to mention item number 46, sir. Due consent from the other side for the response.
46.
My lord.
The request made by counsel.
For the respondent, my lord.
You are for the respondent.
Respondent.
The concept of the counsel other side, but to be tested after 4 weeks.
Item number 90, madam. Here the Joint Secretary held an informal welfare department. Day before yesterday, they have filed affidavit in opposition. So I pray for 1 week time to file affidavit.
Item 19 is
Item
the
nine.
request of counsel to the petitioner and the after 2 weeks.
Obviously.
Please, your lordship, I beg to mention item number 39, lordship. Yesterday, I have filed a IA, lordship. Lordship, kindly matter may be come with along with item number 30, IA, lordship.
Next week,
Lordship.
Lord, item number 38, my lord. It may kindly be adjourned for 2 weeks. I have taken the consent from the
you are for the respondent.
petition.
Petition item 38 be tested after 3 weeks. 3 weeks.
May I please, your lordship.
39 is next week. No, yeah.
May I please, your lordship. Due to some personal difficulty, lordship, I beg to mention item number 24, your lordship. That is matter come up next week, your lordship.
24 is fixed matter. It goes after 4 weeks.
Lordship, kindly
24.
next week, your lordship.
24.
They have not yet filed their reply also.
No, next week. Why do you want next week? What is the urgency here?
Yes,
What is the
lordship,
matter about?
only today, lordship, I have some personal
What
difficulties.
is the issue?
This was regarding the engagement of a helper. She was the first position holder. Anganwadi helper. It was the first position holder. Instead of giving her, they have given the appointment to respond the second
We
position.
can't fix a date. We can say only next week. Let it come. No date can be given. Next week at the request made by counsel.
Lordship. Lordship, I beg to mention item number 17, lordship. Lordship, this is works as employee matter, lordship. Lordship fix the matter, works as employment on 31/7, lordship. So this matter may be taken up.
It is submitted that similar matters are fixed by this court on 31/7. Counsel to the petitioner, therefore submit this matter. They don't.
May I please, your lordship, I beg to mention item number 40, lordship, with the consent of the other side, may the matter be taken up on 25th of June. I am appearing on behalf of Mr. B.K. Singh.
Here,
My lord, it is a matter of compassionate appointment, my lord. May I pray for fixing a date on 25th, my lord? Which concept of
25th, the last day.
no, 27 last date, my lord.
27th,
27 last.
27th.
lord.
A compassionate appointment, that's why, my lord. The wife and son is suffering. Lord.
It's likely that last week will be a motion week.
We'll take a chance, my lord.
Not 25th.
Obliged, lordship.
May I please, your lord?
FCI.
May I please, your lordship? Lordship, I kindly beg to mention item number 16 on behalf of RD as he is engaged in today's function. Kindly fix a date on next week, your lordship.
Let it be in July. After vacation.
It would be quite delayed. Kindly next week, any date of next week, your lordship.
The week beginning from 23rd. Based on the week beginning.
May I please, your lordship? Lordship, I beg to mention item number 54,
54.
lordship. Consent is taken from the other side, lordship. This matter may be adjourned for a week. And for the cooperation department on behalf of
You are for?
SK Talukdar.
You
Cooperation,
have taken consent.
lordship.
Item 54 to be listed after 3 weeks. The request made by the Red Scale on behalf of the corporation. Consent to the council of the
Obliged, lordship.
May it please your lordship, I beg to mention for listing of written statement for order.
The mentioning for listing is in court number 5. Not this court. Go to court 5.
May I please, your lordship? Lordship, I beg to mention item number 27. Lordship, matter may be adjourned for day.
27 to be listed after 4 weeks. The request made on whose behalf?
behalf of my senior HR secretary.
May please your lord. My lord, arbitration petition for appointment of arbitrator lord.
Content, total content by Recruitment courts. Within 1 week. Least after returning.
Eligible.
Some instruction regarding the
Appeal.
appeal, my lord.
Appeal lordship, if I may take your lordship to. Page 36, lordship, page 36, lordship, my instruction is we have not received it. But the one before that, which starts at page 33, that is undated,
That is
not dated. Annexure 12.
no, but are there any appeals pending or not?
Lordship, Annexure 12 we have replied. Annexure 13, Lordship, my instruction is we have not received it.
What is the annexure 12 and 13? What is the difference?
Lord,
12
it's-
also
It's more,
is
yes,
a dismissal order.
yes,
My lord.
that we
If
have,
the initial reply was not replied, he gave a second representation.
that initial one was Lordship,
You have given a reply.
yes, Lordship. We have given a, like,
Have you it's not annexed yet?
No, my
that
lord.
is not there. Lordship.
You give a copy.
Yes, definitely, I'll give him.
What do you want to do about
My lord, I'll go through it, my lord. Everything.
the expected after 4 weeks? Enabling the rules. The order passed in the appeal referred by the petitioner. Copy of the appeal memo being included the Section 12. Their petition is ordered in place before court pay by the London. Listed accordingly after. Yes. I think the
Same field, what is last occasions I was likely to obtain instruction. My lord, that appeal number has been, my lord, registered 165/2020
pending.
pending. Lord.
So you dispose it of.
Lord, dispose it, I give a direction, my lord, in stipulated time, my lord, it can be.
It is 3005. The standing council. AP referred by the petitioner has been numbered
165.
for 165.
Lord.
Same, I think. That view, since there is already an appeal referred by the petitioner, pending before the this court considers it appropriate to close the matter and state the of the before which authority
Director of Plan Order, as for number 2, Lord.
authority will ensure that the appeal is
Director of
disposed
Land
of
Record and
by
Service.
passing a speaking order within a period of 60 days. On the date of 60 days,
But that the hearing, my lord, it can take, my lord, that's some of the parts.
90 days. 90 days from the date of any order that is passed, closing of the appeal, copy thereof shall be served on the petitioner. The appeal hearing in the appeal shall be conducted by the appellate authority as per the procedure. The petition closed. Start with the-
Apply, sir.
Or in this particular, PN forward directed to obtain instruction.
Yes. Where is the help?
There's similar petitions that have been already pending, my lord. There's similar petitions that have been pending. Can be tagged with that one regarding person with disabilities.
Issue notice there.
No,
Does it come?
the RP Goswami on behalf of
RB. Yeah, both.
Miss MD Bora for 1 and 2.
Take step. Airport to the standing house. If available. Wait. Then one. Wait. Wait. Then necessary evidence. Sit after the return.
This has become infectious of course. Already both the petitioners undergone various schemes.
Unappeared to the petitioner report. It's a take away.
Exponent 120.
Submit that the petitioner be accepted the PRS
Yes, a scheme
opted for and it PRS.
for the contingency mania locus.
By the court.
Contingency mania locus, one time settlement. This is the scheme.
So when is that order passed?
This order passed in the year 2024 lawsuit.
Give me a book.
The various effective from the September 2024.
The go the court communication extract of the mind extract of the mind for the cabinet meeting which respect of the proposal for approval of the proposal in respect of the approval the proposal for voluntary retirement scheme for regular employees and one-time settlement between payment to contingency manual of ASAFD and re-employment of those within bracket not opted for PRS in the AFS AFCS
AFCS.
HCL. Is that
Lawsuit.
what is AFCSCL?
Lawsuit. This is
The directorate of appeal. It submitted that the petitioner had opted for PRS and accordingly to PRS that they made effective from September
they are contingency mania local.
2020. That view of the matter. View of the petition made by the council and the extract of the PRS plates, extract of the approval evident position plates to the court. pending IAs are also dismissed. Interim orders remaining.
List.
My lord, matter may be possible for timing.
No timing.
It's only, they have to provide the consent letter.
You have the consent letter.
My lord, my lord, council is on the way.
Matter be
Council.
listed next week as it is submitted. Council for the petition is not available in court. The will come on Monday, Tuesday. Tuesday. It's on Tuesday.
May I please, your Lordship, here, Lordship, there were two directions, Lordship. One was to complete the DP against the petitioner that has been concluded. Now only the consideration of his representation for voluntary retirement is left, Lordship. The department is working on it, Lordship. The department is seeking 1 week's time, Lordship. If the matter can be listed on 23rd, Lordship, we can.
When is the order?
Order is page 16.
2017 order.
Page number.
Page number 12.
16. 16 is the operative part.
Operative part is 6. Okay, after 25 years, they completed the DP. Now 7 years of order, Lordship, still did not complete.
Have you served copies of the DP?
Lordship, yes. The petitioner, Lord, that my
If the DP has been completed, he has to be served with an order.
that he has not asked for a copy.
That order.
He doesn't have to ask for.
Lordship,
You are proceeding against the
yes, Lordship, that I'm not aware.
You get instructions on Tuesday.
Yes.
Tuesday.
Lordship.
Coming Tuesday.
Lord.
Any matter be listed on Tuesday and enabling the respondent comes. How we have regards status of the completion of the departmental proceedings stated initiated against him
And the voluntary.
and
representation.
Disposal of the
For voluntary time.
of the writ. Please begin.
Lordship.
Lordship, in this contempt petition, the order is still not complied, your Lordship.
No, what happened, my lord? In the meantime, my lord, the entire amount has been received by the GMC, my lord. They are involving 583 persons. Final calculation is going on by the area retirement pension will be released.
How long will it take?
The lots will post in the first week of August, my lord. In the meantime,
August.
Yes, no, 583 files have to be posted.
Lordship, where the order is
583 petitioners are not before the court.
And the entire amount has come. You have to pay the all.
Sir, Ora, you are in contempt.
Lordship.
You are already in contempt. You are asking for further time.
The amount has not come only because the amount was initially amount was there. Now kind of full amount has come. Money. Process, but entire thing has to be processed. Money.
Don't make it difficult for the court. There is an order of the court you have
Lord,
to comply. You did not pray for extension of time. Nothing. You are on assurances the matter is.
In the meantime, my lord, all this regular pension has been released, my lord. Only thing the area part that amount has recently come to the GMC's proper, my lord. Now we are just have to do the calculation of all this when the accounts department is calculating it for the 583%. Order was for the entire one, my lord. I mean, 83% was there.
This is a consent order. To the party, the standing council considered that the entire funds necessary for disbursement of pension,
Area pension.
to the petitioner. How many petitioners?
Here, my only one person has come
In
about.
the contempt, there is only one.
To the
But there,
petitioner
initially it was 583.
in WPC 596 of 2020. By the PMC the authorities are presently working, presently undertaking the exercise, determine the individual amount payable. Further 4 weeks time to the respondent takes the exercise. Considering it listed after 4 weeks.
Yeah, please. In persons to the Honorable Court order, they have filed the affidavit.
My lord,
They have filed the affidavit in.
Lord, latest question is that Soil Consumption Department has
Where is the
Record.
direction?
recorded financial.
Case 14, Lordship of the Council. Operative for this case. That for
Yes.
Look, Soil Conservation Department has recorded financial section and it is forwarded Finance Department. Now, Finance Department will do the.
Lordship, if I can just also. Lordship, FOC has been sent. Lordship, once the FOC is granted, then the money can be given. It's written in the meantime. FOC proposal in respect of the has been excellent. Has been duly submitted to finance fund. The 5th of June, Lordship, it has been sent. Lordship, so once the FOC clearance is given, the petitioner will get his money. I can get my instruction.
You get it
Yes, Lordship.
next week?
Yes, Lordship. I'll just take a copy of the.
It will be listed on 19
Lordship.
19 June. Enabling Mr.
Yeah, that
Is only for 5.
Finance Department.
Lordship.
Citizens. In view of the submission made by Mr.
the correspondent number 1, 3.
P. Hazarika.
Yeah.
Correspondent
Correspondent number 1, 3 and 4.
1, 3, and 4. Then the concerned department, soil conservation department, is already put in with the finance department.
Lordship will have sealing proposal, Lordship, because that is the last day.
They have not for what proposal? Sealing.
Sealing proposal. So once that is there.
Then the proposal to sealing. Fine. That will be listed on 19th.
Lordship.
Offline.
Then
In this matter, respondent number 5 file affidavit, Lordship, and to file reply.
I
Yes, Lordship.
In the
IA for the stay of the impugn gradation list published on 27/5/2020, Lordship.
who is filed the I? You have filed the I.
Yes, Lordship, I have filed
Then
it.
they have filed an affidavit.
The affidavit in main matter, Lordship. In IA, they have not filed any objection, Lordship.
Corrected.
Lordship.
They filed it in the I also.
I also.
Now,
Lordship, after some time, Lordship.
after some time, not to- it, submitted that the respondent will file their affidavit in the state petition 18 of 2023 as well as IA 1351 of 20. It will be listed after 4 weeks.
There is 2 weeks, Lord.
2 weeks. Not 2 weeks, let it come after 4 weeks. So that the respondent, they file the rejoinder into advisor. Your name,
We show it.
appearing for
Hey, see on behalf of the respondent
of the
report.
Obliged.
7.
appears. Call Mr. J. Review department and map or the
State respond.
It's after one.
Plus. Well,
Wait, please. By judgment and order dated 28/8/2024, direction was given to the respondent to appoint the petitioners. They are in the category of EWS. Substantial time has elapsed. They have not acted to the directions of the court. The order starts at page 15. And the operation paragraph is at page 20. Para 13. I mean, it is slowly a lot.
Yeah.
Para 13, it says, in view of the above, the writ petition is allowed by directing that the petitioners be afforded the appointment to the post of junior engineer civil in the P&D department pursuant to the state recruitment process. It is, however, made clear that such appointment is to be made in the existing vacancies and without disturbing the appointments of the private respondents. The writ petition accordingly stands disposed of. Interim order dated so and so stand merged with this final order.
AD card for respondent who is awaited. Yes,
I'm for respondent one, Lordship.
anything?
Lordship, we need 1 week's time to file our affidavit.
It is 3 sharp. I will for the one. For week's time, 1 week. Week's time. However, they're made in the law. It's not dated 10/25. AD card. We listed after 3 weeks.
Yeah.
We listed after
Yeah.
3.
Date if possible.
After 3 weeks. It is up in July only.
Last part of June. Right.
3 weeks will not be over. We'll have it immediately on the 16th of July.
Lordship, can it be on 15th or 17th?
7.
15th or 17th. Why 15th or 17th?
Lordship, my senior will appear in this matter, Lordship.
Then we'll have it on 18th.
What?
18th.
Much obliged.
Lordship, in this case, petitioner died, Lordship. We have filed IA for substitution of a wife of deceased petitioner, Lordship. IA number 1347.
Have you served copies
Lordship.
on all?
Lordship.
Copy not served to me.
Lordship. We have to
I am for respondent number 12.
Not served.
Not served.
serve, Lordship.
We throw him the copy. He says he's not.
When it is for respondent number 12, 12 purpose. 12 purpose. Not served.
He served copy. But why is it not served copy? Last order says you have to serve copies to opposite parties.
We have
That to be listed after 1 week as the counsel appearing for respondent 12 after. You know the court that copies of the IA will serve. List again after 1 week.
Much of it.
Serve copies. Why don't you serve?
Lordship.
hey, wait for some time to file reply in this matter.
You want some time to file reply.
Good.
Yes.
A date may be fixed.
He consider 4
weeks then.
week time.
If it is not inconvenient, if it is not inconvenient, a date may be fixed.
4 weeks time to file. They're not affected to file the listed after 4 weeks. It's 18 July.
Look, can it be on the week thereafter?
You said 4 weeks. We give you 4 weeks, 21st. 21st July.
May please your lordship.
Yeah.
I have filed one IA in the contempt petition lordship for implement of the new incumbent lordship.
Who's for the respondent? Otherwise,
Please, a guy on lordship, I have already started copy to her lordship. He is appearing.
the IA has been filed. Who do you want to implement?
Director General Assam Rifles lordship. I have mentioned in lordship paragraph 7.
Director General Assam Rifles. Lieutenant General Vikas Akera, AVSF, SF, Director. He responded to three in the contempt, but clear. Director General Assam Rifles has since evident of it, and the opposite party has been appointed as director. The opposite party, Seri party. Alternate CTC, group of them in served on court. Nevertheless, court has considered the now without just that as uh, earlier compared to the office of the director general was already carried as a party respondent, and by way of this present the present opposite party now with with subsequent PSU office that is required to be added as a party. You right. It is party board. The newly completed opposite party will be issued this and get an opportunity to get a love like so weeks from today. The right POPI order passed today. I generate is funding for court. It is the new depleted response by registered 480 as well as by usual courts. Petitioner will file amended court title to be listed after the return.
Pertains to discharge from service, pleadings are complete, my lord.
It is complete.
My lord.
Happy sir. Lordship, kindly pass over the matter for the day, Lordship.
Right?
My senior is in legs, Lordship.
Here we'll admit and fix a date for here.
My lord.
Submitted at the bar. It will good. And be listed for hearing in the month of August. The respondent will keep the relevant this record pertaining to the proceeding which shall be dated in the dismissal of the treatment. available in court for perusal if the need so arises. If you have.
Item 18.
Thank you, Lordship. Lordship, by compliance of this honorable court order dated 6/10/2021 and also 20/12/2021. Lordship, will file appropriate court fee, Lordship. Therefore, time may be granted for today.
Petitioner Great Court has granted the further time. Submit the appropriate court fee for the registry. Registry will thereafter make necessary at least after we'll give you 3 weeks. At least after 3 weeks.
In this matter, Lordship.
Passed over.
Okay, Lordship.
21.
Let's say petitioner praying for compassionate appointment. Lordship, he is still working in the department, Lordship. Petitioner father died, Lordship. After he applied for compassionate appointment, Lordship, and he is in contextual basis, Lordship, he was appointed, Lordship, in page number 31, Lordship. And page number 34, Lordship, Commissioner forwarded his case, Lordship, and after that, Lordship, petitioner approached this honorable court, and honorable court, Lordship, in page number 53, operative portion, Lordship. May I read, Lordship? Page number 53, Lord. Lordship, in view of the concern of the parties, the petition is disposed of with a direction to the respondent number 5 to consider the petitioner's application in terms of the parameters of and guidelines laid down by the state government and this court in next meeting, unless the same has already been considered. The same should be done within a period of 3 months.
Yes, respondent.
Can this matter be taken up as full or solid process? File is not accessible today. That is the reason also I cannot.
Monday? Monday?
Yes, also.
We'll list it. State.
Lordship, compassionate appointment, Lordship.
Lordship, we've already filed our affidavit, and Lordship, the SLC has rejected the application of the petitioner. The petitioner's father, he died in the year 2005, Lordship, and he applied in the year 2015.
No, not.
Lordship, the rejection order is at page 43 of the read petition. Second paragraph, the committee examined and considered each case as presented by the member secretary and decided the cases depending on the findings with reference to the vacancy position, date of submission of application, upper age limit, educational qualification, economic conditions, balance of service, etc. and finally decided the matter on compassionate ground. The committee also took note of the guidelines laid down by the Honorable High Court in WPC number 3875/2006, Achyut Ranjan Das and versus the state of Assam and others, and OM issued by the Personal Pay Department and various directions of the Supreme Court regarding appointment on compassionate ground. And thereafter, Lordship, the case of the petitioner could not be considered. The SLC's decision in the remarks column, Lordship, could not be recommended as per OM due to late submission of application.
Then
Lordship,
where is that order of rejection?
Page 43, Lordship.
43, 40.
and DLC recommended in page 40,
No, but it is rejected on
Lordship.
late submission. When did your father expire?
2005.
And when did you submit?
Lordship,
2005.
petitioner, he attained, after he attained a majority, Lordship, in page number 34,
No, no.
Lordship.
When did your father die? 2005.
Lordship. But he was minor, Lordship, that time.
So
But
then this
immediately
Santosh
after,
judgment will be applicable.
immediately after attainment of majority, Lordship.
How many years?
Lordship,
When did you attain majority after the death?
in 2015, Lordship,
After 10 years.
after 10 years.
How is it?
The
Lordship.
petitioner was 9 years, Lordship, when his father died.
Lordship.
Even under 2015 route, it is typer.
Lordship. In similarly situated person, in our Lordship, page number 48, Lordship, and coordinate bench and given, Lordship, in
48.
48, Lordship. Operative portion in 15. Page number 52, Lordship, paragraph 15, Lordship.
This is a delay of how many days? 2-3 months. 3 months. Page number 49.
Lord.
Paragraph number 3.
Lord.
Petitioner's husband died on 3/7/2008. He submitted application on 9/10/2009. So there's a gap of 2.5 months. Here is a case of more than 10 years.
Lordship. Lordship, may I pay some time, Lordship, to satisfy you?
Can you satisfy in view of the Supreme Court? Counsel for the petitioner
sometime.
submits that he would like to give some authority in support of his case. Let the praise for the matter be listed again after 3.
TPL.
My lord, this is an application for appointment of arbitrator on default ground, on default ground. Because we issued the notice and there was no response from the respondent side, my lord. And the dispute, my lord, in this case arose due to the termination of the contract, my lord. And here, my lord,
any objections here?
Lordship, in fact, I have not filed any objections, but I think, Lordship, if my friend will agree, I think this is covered.
yes, covered case.
Covered?
Yes, covered.
By which order?
By this. Page number 230, my lord.
No, not 230. 33.
233, my lord.
So this a case where you used to have response, or is it a case you insisted on appointing your curated candidate? He referred for arbitration.
Lordship.
Then you refused to reply, or you gave him a list of arbitrators?
No.
No reply was there.
No reply.
No.
And as per the national insurance, general insurance, my lord, there is no scope for
No, but would reply at the period go.
That's
then your lordship has to appoint the arbiter.
This judgment is on a different. It's not whether it is 20% or something like that.
here also, Lordship, there is a clause here. If I may,
Similar clause is there.
if your Lordship will come to page 85.
You have not raised your objection. This order has not been saved before the effect.
That Lordship, but here, Lordship, if your Lordship will see the clauses, clause 8.
So it is that below 20%.
That
Right, heard. This arbitration petition is filed with the petition. Praying for appointment. It's not the same. Is served on the respondent. Concur on the appointment. Where is your notice?
At page, my lord, this is 227, my lord. Sorry, my lord, 228. 228.
You did not name an arbitrator.
No, my lord, there is not, the clause does not say for naming the arbitrator.
Oh, in that way. This is a 21 notice.
Yes, 21 notice.
You did not name an arbitrator.
It is not requirement of the naming the arbitrator. I invoke the arbitration clause, and there is a procedure. They will refer the nominated name of the arbitrator, and out of the three, I have to choose one name, but they fail to act as required under the agreement. So, under section 11(6), it is clear. Once the appointing authority fails to act as required under the agreement.
Fact involved in the present case that the petitioner entered into an agreement. The petitioner was served with the work order by the NFRB. Action made went to page number 37. The Diksha has the work order put on 8/8/2018. Agreement was entered in by the agreement had clause. Which clause?
Clause number 6.0 at page 80, my lord.
80.
80, page 80. Clause number 6.0, settlement of dispute.
Clause number 6.0 provided for arbitration in cases of disputes which arose by between the petitioner. Your work was terminated.
Yes, my lord.
You did not complete the work.
I did not complete. Part of the work was executed.
Proceeded with the work, however, some portion. The contract was terminated. So the petitioner they agreed. It broke clause 6 of the agreement or referring the matter for arbitration by issuing a notice. Dated 8/1. However, withstanding the same notice being received by the respondent, as claimed by the no arbitration, no nomination for arbitration. Eight. Being reviewed under the thereafter, architect Chowdhury Lana DSPI here for the railway property submits that so actions that have been filed. The railways were required to appoint an arbitrator. They curated manner only subject to the matter being arbitrable. Where is that clause for arbitration? 20%.
So that is at page 85.
85. 64.
8.0.
Submits that the arbitrability of the dispute governed by the contract provision, and it is only in matters where the disputes are they are less than 20%. When is it arbitrable? Less than 20.
Yes, it is their contention.
Less than 20% can be arbitrable. In the present proceedings, disputes are more than 20%. Therefore, bring the matter. Therefore, apply. What is the judgment? Data switch. Data switch here.
Latest case, my lord, is another judgment of Honorable Delhi High Court is there, where 20% matter was there.
Will you give us the Supreme Court judgment that the right to appoint ceases after the expiry?
Yes, yes.
In data switch here. What is it? In notice period expired, lose their right to appoint. Here, the present case, after issuance of the notice under section 21, without there being any reply, issued by the respondent, that which the written data and the LPI. The respondent lost their right of reflect. Such circumstances, the question of whether disputes are arbitrable in view of clause 8, read with clause 63, 64, has already been decided by a court and bench. CSR
Page 233.
DSR Ventures Private Limited was disposed of by judgment and order dated 1811. Courted bench held by referee the court laid down by the that is question whether the are set up can that you have that of it is to be updated. And due to the fact that the respondent failed to respond to this issue under section 21 the Arbitration Act and has also not filed any objection, the present court considers it appropriate to allow the application of the ethics and appoint an arbitrator. In terms of the application,
My lord,
the court proposes to appoint.
my lord, we agree for the appointment of Shri Vinod Kumar Kandak, retired district engineer judge.
Name is here.
Maybe there.
I don't think his name.
May not be there here.
Anybody?
Anybody? Shri Mahmood is also there. His name is there.
Whose name?
Shri Mahmood, retired district judge.
Mahmood Ahmed.
Yes, my. Yes. Yes, got it, got.
Yes. Sri Mahmood Ahmed, retired district and session judge of Sub, is appointed as the arbitrator. Decided. This appointment, however, is subject to the written declaration by submitted by the arbitrator. If the declaration replaced court by the next week, the parties will intimate the proposed arbitration as also the next week. Matter be listed again after 3 weeks, 2 weeks.
After 2.
The vacation.
After vacation.
Why after vacation?
He
We
may go.
appoint and you appear after vacation.
Yes.
If he agrees to the appointment,
Yes.
why keep it pending? We'll have it on 23rd. Weeks.
Twenty-four.
We'll have it after 10 days.
Yes.
That will be listed on 24th.
Much.
Both of you.
I was just telling my friend also, there's been a recent trend. Advocates are also
Yes,
being
senior advocates may also be in some cases.
It is not there in the list.
At least it is the difficulty here.
Perhaps someday his name will come there. Lord.
No, no.
Why only his name
Yeah,
your name
other
will also be there?
senior advocates are there.
Yes.
Much.
Yes.
On the last occasion, my lord, the time was sought for by the forest department, my lord, for taking instruction or filing affidavit. But that has not come yet.
That is not done. Now, what is the matter about?
Matter about, my lord, the first matter is, my lord, the person before your lordship is a retired forest officer, my lord. Inquiry was conducted by a person, my lord, a presenting officer. He himself turned to be a witness in the inquiry, man. Dual role he has played, my lord. So accordingly, we challenge that inquiry proceeding. And next case is my pensionary benefits, my lord. I got retirement in the year 2021, but I have not been provided with the pensionary benefits. Thereafter, my lord, during pendency of the case, my lord, they passed then another order. Accordingly, we had to file another writ petition. Affidavit has to come from them, my
You are challenging what disciplinary proceeding.
lord. Disciplinary proceeding in respect of the report, my lord. Here, your lordship will see the presenting officer, he himself turned to be, my lord. Lordship will see page 66, my lord.
Page?
Page, lordship, I'm coming, my lord.
What is the name of the presenting officer?
President, some Goswami, my lord. I'm coming to that, my lord. Inquiry, your lordship will see page 53 to 62, my lord. Presenting officer name is, my lord. Lordship will see page 57, last part, bottom part, my lord. The presenting officer A.M. Goswami AF is presented the case of the charged officer who submitted written replies in response to the question asked during the hearing, and same is briefed below. And now, my lord, lordship will see he himself turned to a witness in the proceeding. Page 58, my lord, serial number 2. He became a prosecution witness. 58, serial number 2. A.M. Goswami AFS so-and-so forest office of the so-and-so forest is a DFO, and he has posted at so-and-so Golpara division, and during the joining Rafiqul Islam has the forest ranger.
This is the presentation of the case by the presenting officer. That is reflected.
Presenting officer is a different malady. He has to be neutral. He cannot be, my lord.
Page number 58.
My lord.
Is not examination of witness.
Yes, it is there, my lord, examination of witness. I'm coming to that.
You read the page number 57 last.
My lord.
Please read it again.
57 last is, my lord. Second hearing, so the presenting officer A.M. Goswami Golpara division presented the case. Charged officer submitted a written replies to the question asked the during hearing, and the same is briefed below.
Below.
Below. Now, lordship will see.
No, this 58 is the briefing of the case as presented by the presenting officer.
Lordship will see. A.M. Goswami, Deputy Conservator Forest, so-and-so, Forest DFO, he stated and he posted so-and-so, Galpara, so-and-so. During his joining, Rafiqul Islam Ahmed, Ranger, the then IC was functioning as a range officer, so-and-so. A.M. Goswami, Deputy Range Forest Officer of the Social Division, stated that he is a witness of the prosecution, my lord. Stated that Rafiqul Islam Forest Range, the then IC was charged.
Pick up words here and there. This is a case of the presenting officer presenting the
No,
case
my
on
lord.
behalf of
In
the
other
department.
pages also, my lord. Let them come with the affidavit, my lord.
No, let the records come. Your
Yes,
affidavit is
yes.
not coming. You bring the record.
Yes, yes.
Can be called.
Let the since this is the matter putting to challenge the disciplinary proceedings initiated against the writ petitioner in the WPC 59. The respondents have also been granted sufficient opportunity by their affidavit. You have filed a reply affidavit.
Yes, I have replied and I have questioned also, my lord, about the locus.
There is an affidavit filed on 10 December 24. What is that affidavit?
My lord, after that, my lord, nothing has happened, my lord.
No, one affidavit is filed by you, petitioner.
My lord.
What is that affidavit?
That affidavit is, my lord, during pendency of the case, there is an
Additional affidavit or reply affidavit?
additional affidavit, my lord. I filed an affidavit that is additional affidavit, my lord, at page date, my lord, 10/12/24. There, my lord, what they
No reply has been filed by the respondent. According to this is very
have not filed affidavit.
pretty hearing issue with the records equal for the bank. So hearing the month of August.
It may be fixed, my lord, retired person, my lord, nothing like.
August, 7th of August.
Can it be little bit before, my lord?
Fifth.
No.
5th of August.
2 days concession.
The records will have to be called for.
Yes, yes. My lord, from this Rehabari, my lord, nearby.
Instead of July, we are giving you first week of August.
Both the matters, my lord.
Both the matter.
But. It is to mobile phone, bana hai.
Challenge to releasing the petitioner from NC to the state lordship. Instructions were awaited. Affidavit is on file.
Yes, who's appearing?
NC. State supposed to file it.
Heard the BP Moral that spot them. Anyone for respondents?
NC is represented.
I'm for NC itself.
Is anything you want to submit?
No, Lord. How many is supposed to file it?
It's set for hearing. Reporter passed. Native.
This pattern, my lord, the use from the APSC is still awaited, my lord. They have given a reminder on 5-6 again. And the secretary is also personally has pursued the APSC to give the views at the earliest. Will require some more time, my lord, maybe further 2 weeks time.
What are you challenging me? Disciplinary proceeding?
Yes, my lord. Here, my lord, the petitioner was suspended with effect from 4/3/2023 due to his, my lord, deemed suspension, my lord, due to his, my lord, arrest in a criminal case. My lord, on last occasion also I have at page number 57, my lord's order was there. Yes, my lord. My lord, order was there, my lord. 59 is the operative portion. My lord will see at 59, under such circumstances, the court is of the reason. Finally, my lord, the entire exercise will be completed within a period of 2 weeks from the date of receipt of the certified copy of the order. No order, no, my lord.
Who's for APSC?
APSC is not a party, my lord.
Not a party, but you have sent it to APSC and you are waiting for their opinion. What is it?
APSC
Please call the standing council APSC.
Silent.
Standing council APSC. We'll take up after while.
My lord.
Yeah, please, Your Lord. Lordship, on the last occasion, your lordship has asked for your lordship's judgment on 20% of the railways, my lord, for appointment of officers. Madam, Mr. Kekovo informed me that he is on legs.
We just passed an order.
Mal.
Let him come. Sign on this bill.
Lordship.
After while.
One.
Yes, sir.
Yes, Lordship, in item number 31, Lordship, instructions are still awaited. Matter is regarding promotion of the petitioner to the post of head assistant. That regard, they have made a representation, Lordship. We have communicated.
We'll direct them to dispose it.
DPC has already been
DPC has been held.
yes. For 13/12/2000.
Which department is it?
The health department.
Health. They have to either produce the record or file affidavit.
Miss Lordship, that is, Lordship, that is why I'm asking only for 2 weeks accommodation, Lordship. In the meantime, we have already communicated Department, Lordship.
2 weeks time. Yes.
That will take.
The rate. Yes, sir. The rate to be had. Help.
Name was
Instructions are required as to the outcome of the proceedings of the departmental notes. It is information the court after 2.
it's a date.
Last week of July.
Will be, we'll have it on the first week of reopening immediately after the
Yes, Lord.
based on 18 sorry, 18 July.
Lordship. Right.
May please, I appeal for Mr. Roy. He is out of decision. Mr. Asapar is out of decision. It may be taken up in the next because
Earlier, मतलब there's not time to obtain it.
he has gone to Meghalaya.
All right, we'll have it on Wednesday, 18th.
Yes.
Matter be listed on 18th as it is submitted. That access Roy is up. Please inform him.
Aulad.
It's for him.
May appeal, Lord. Regarding compulsory appointment, Miller. My case is covered by Miller, that order Miller 3/4/25 Miller.
Yes.
It's both of Miller.
Covered, not covered.
Lordship, here also the petitioner father, the deceased employee, when he applied, he was a minor at that point of time when his father died, Lordship. And there is a judgment of the coordinate bench, Lordship. May go through the judgment. Dada. Last page, Lordship, at page 5 of the judgment, Lord. Second paragraph, Lordship. There is no doubt or dispute about the fact that there is no government circular in the state of Assam permitting a minor to submit belated application seeking appointment on compassionate ground upon attaining majority. Rather, the standing government circulars at relevant point of time had laid down that such application should be filed in a time-bound manner and considered as expeditiously as possible. It is to be noted that even if the age of the petitioner on the date of filing of the original application in the year 2007 is taken into account, even then it is apparent that he had survived for more than 16 years without any government employment. Therefore, there is no justification for this court to presume that element of compassion is still present in the case of the applicant or the writ petitioner. For the aforesaid reasons, Lordship, the petition was
Misleading statement given by the former side, Miller. Miller, very this fact is that, Miller.
When did your father expire?
Yes, Miller. My father, yes, petitioner father was expired on 28/7/2022, Miller.
There is a
And
dispute
they filed-
regarding the date of death of
Miller,
his father also.
I'm submitting.
Who is your father?
Miller,
What is the name?
name Miller, Praveen Chandra Bora, Miller.
Provin Bora.
Yes, my lord.
What is the date of his death?
My lord, 28/7/2022, my lord. This is the date.
Page number 16 is a death certificate which says 7/7.
My lord, yes, 7/7, 7/7. 7/7/22, my lord.
But you said 28/7.
Some mistake is there. In my petition, mistake is there.
If mistake is there, then your
Lord.
petition is formed by an affidavit
My lord,
stating these statements to be true. If there is a mistake, you should correct it.
no, my lord, actually, date is mistaken because date of registration is putting here, my lord. That's why, my lord. Date of registration is, my lord, 28/7, my lord. That date was put here. Otherwise, my lord, it is my lord, fact is that, my lord, petitioner father was, my lord,
How old were you on 7/7? What was your age?
he was major, my lord, at that time, my lord.
He was major.
Yes, my lord.
Do you have your birth certificate?
I have not annexed, my lord, but record is there, my lord. My lord, thing is that, my lord, earlier bunch of cases, my lord, that was filed, my lord, and subsequently after came into notification, my lord, to 24, my lord, and all the petitions have been, my lord, withdrawn and filed fresh, my lord. And thereafter, my lord, onward court, my lord, has, my lord, passed the order, my lord, common order, without going to the merits. Dispose of all the matters, my lord, giving the period of 6 month period, my lord, to the department. So, my lord, in earlier bunch of cases, my lord, department filed the affidavit, my lord, and I am just annexed, my lord, part of the affidavit, my lord, page 27, my lord. Page 27, my lord, my petition, my lord. What they have done, my lord, in department, my lord.
No. First tell us your facts. After your father expired,
Not as expired, my lord.
you applied.
My lord, thing is that, my lord, petitioner father was, my lord, serving as a constable in 3rd Assam Police Battalion, my lord, Sitapur, my lord, Jurat. Owing to physical incapacity in post cardiac arrest, my lord, he compelled to go on retirement, my lord, in the year 2011, my lord. Thereafter, my lord, on 2014, my lord, he applied for compulsory appointment, my lord.
After retirement.
No, my lord. Yes, my lord, after retirement.
After retirement.
Yes, my lord. Because he was retired, my lord, on compulsion, my lord, on BRS, my lord, because he was physically incapacitated.
Is the compassionate? Where is the scheme?
Scheme, my lord, in page, my lord, 40, my lord.
40.
Yes, my lord. In example 11, my lord. Fourth line of, my lord, first paragraph, my lord. May I read, my lord? Retire prematurely on being permanently incapacitated as declared by the certificate issued by the state level standing medical board and receive invalid pension under provision rule 82 of the Assam Service Pension Rules, Miller. Similar, here is the medical certificate here also, Miller. Page, Miller.
No, we are asking you one question, whether compassionate appointment or engagement through compassionate appointment is available for somebody who took PRA, or is it only in cases of
That
death?
thing is, that Miller, already DLC has been, Miller, considered my case, Miller, and subsequently, Miller,
we are asking you a question, give us a reply, yes or no. In terms of the office memorandum,
yes,
is there any provision to say that even employees who were serving and were been given PRS on health ground,
yes,
their dependent members are available for compensation? Show us from the scheme office memorandum.
Miller doesn't say directly, Miller, any here constitutes the premature retirement.
Then
Only thing is premature retirement
die
is
in harness. You've not read your brief properly.
that I'm not praying for that be directed to the department. That department be not take their actions on Milot depending on the Milot facts. Because
Where is the DLC recommendation?
DLT recommendation Milot Page 27, Miller. Finding of the observation, Miller. This is a part of the record filed by the Miller's Department Miller on affidavit, common affidavit. Last, Miller. Grounds on which decision is taken by SSC and DLC. DLC minor dated 26/6/2014 recommended the candidate, Miller. Number 2, SLC minor dated 6/6/17 could not be recommended for the post because of late submission of application, Miller. There is also discrepancy, Miller. Otherwise, my case was considered, Miller, by DLC, Miller. So the department will be clear, Miller, regarding the fact, Miller. This is the affidavit, Miller. Only Miller department will clarify the fact, Miller. Otherwise, Miller, all papers have been submitted, Miller, by the petitioner before that, Miller, concerned authority.
So the recommendations are not here.
Miller.
DLC recommendation.
Yes, Miller.
Page number.
No, Miller, order was not with me, Miller, because it was not provided to me, Miller. This specific clear statement is here, Miller. None of the reports that DLC SLC was committed to the petitioner. Only after filing of the affidavit, Miller, that thing is revealed, Miller.
So that affidavit is filed in some other case.
Yes, Miller. An earlier bench of cases, Miller. That was series of cases, Miller. It's a common affidavit, Miller.
You also filed.
Yes, Miller.
What is your case number?
My case number, Miller,
Paragraph
7388, Miller, of 19.
7388.
Miller.
Manos Protein Bora.
Yes, Miller. Serial number 18, Miller.
What was where is your when did your father retire? And from
Miller,
sorry, from voluntary retire. So you submitted after his death.
No, Miller.
Then?
After retirement, Miller?
After retire.
Yes, Miller.
When did he retire?
Miller, he was retired, Miller, on in the year 11, Miller, 2011, Miller.
And when did you apply?
On 14, Miller.
2014.
2014 year.
There is a delay of 3 years.
There is no limit, Miller, regarding Miller retirement persons, Miller.
Who says there is no?
2 years limitation is not was not there, Miller.
No. You have to apply within what is the period? 1 year.
1 year.
1 year. You applied after 3 years. You applied after 3 years.
Well, departmental affidavit does not say anything, Millard, because they filed the affidavit, Millard, considering that
They have not said anything, but the high-level committee report
Yes, Millard.
says that the rejection of SLC was in order. SLC rejected on the ground of delay.
That's why, Millard, my humble prayer is, Millard, Millard, kept pending this petition does not yield any result, Millard. So, Millard, dispose of with the direction, Millard, common order, Millard. Otherwise, Millard, department will take Millard any decision, Millard.
Department has already taken a decision. You have to point out that this decision taken is not as per law, or is incorrect, or is in violation of the memorandum.
But that order was not, Millard, on merit, Millard, because all pending cases in
That
dispose of.
order will be passed on the basis of the directions in the office memorandum.
No, Millard.
As per the office memorandum, how else will it be?
May I read, Millard, paragraph 9 of that order, Millard?
Yes.
In view of the consent of the land councils for the parties, all the repetitions that are pending as on today.
You are reading which order?
Millard, 3-4, Millard. 3-4-25, Millard.
Page number?
Page number, Millard, 75. Last page, Millard.
75.
Yes.
Which order?
The common order, Millard, that was what, Millard, recently, Millard.
Yes.
Yes. Paragraph 9, Millard. In view of the consent of the land councils for the parties, all the repetitions that are pending as on today, which have put to challenge the impugn OM Millard dated 18/9/2024 are to be decided as follows, Millard. Chapter 1, Millard. All the applications for corporation appointments submitted by the petitioners shall be considered and disposed of by the concerned DLC SLC on merit by taking into consideration on various guidelines prior to 1/4/2017, Millard, laid down by the state government for corporation appointment and judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all the corporation appointments by the DLC and SLC which have been put to challenge and are pending in the Guwahati High Court as on 3/4/2025 are set aside, Millard. Number 2, Millard. The entire process for considering the various applications for corporation appointment and decisions to be taken in each case our concerned authorities should be completed within period of 6 months from the date of receipt of the certified copy of this order by the concerned district commissioner, who is also the chairman of DLC, if the matter pertains to DLC. In other cases, the chief secretary to the government of Assam, who is the chairman of SLC, if the matter pertains to SLC. Last paragraph, Millard. It is made clear that in view of the consent of the parties, this court has not gone into the merits of any petitioner's cases, Millard, that are pending, that are being disposed of by way of this order, and as such, applications for corporation appointment should be disposed of by the concerned authorities on merit as they deem fit and proper. The decisions to be taken by the concerned authorities should be based on reasons, and decisions taken should be communicated to the petitioners thereafter. It is also directed that while deciding the applications for corporation appointment, respondents cannot take recourse to the impugn office memorandum dated 18/9/2024. Though the judgment provided herein, that is the case of Devabrata Tewari's Supra, can be considered.
You read paragraph 2, first line.
Paragraph 2, Millard.
First line.
What happens when DLC SLC has rejected? Yes, paragraph 2, Millard.
Page number 72 of the judgment.
72. All the petitions have paid for setting aside the office memorandum dated 18/9/2024 issued by the government of Assam.
Have you challenged this office memorandum here? These petitions were filed putting a challenge to the office memorandum. Under such circumstances,
yes,
could pass the order.
Yes, Millard.
In your petition, have you challenged the office memorandum? Your writ petition was filed in 25.
Yes, my lord.
Office memorandum was issued on 18/9/25.
Yes, my lord.
No, Lordship.
Have you challenged this office memorandum?
Yes, my lord. Here, my lord, paragraph 8, my lord, I have mentioned that one.
You have
Petition.
mentioned, but you have not challenged it.
It's not in the
We are
brain.
setting aside. These writ petitions, all these writ petitions have challenged their office memorandum. Therefore, the matter was disposed of in terms of the direct. In your writ petition, your prayer is to reconsider your case.
Yes.
Send it to the SLC. And you have only mentioned the office memorandum, but
I will not impugn that particular office memorandum, my lord. But here is, my lord, this memorandum is not applicable in my case, my lord, because this is the only issue was raised, my lord, during hearing, my lord.
so therefore this, if it is not applicable, we'll have to decide independently. We can't say that your matter can be closed in terms of this that.
My lord,
We'll decide
my lord,
independently.
the unfortunate thing is that, my lord, I was left out, my lord, because the petition was filed lately, my lord. 1 week late, my lord. That's why, my lord, that series was not included in my case.
No, no, you are not included because you have not challenged that office memorandum. See your prayer. You have not challenged, you have not prayed for setting aside. Yes, we are closing it hard. Council for dismiss. We'll pass on.
That's why the council, my lord, if department, my lord, take the action, my lord, then.
No, no, we are dismissing you. We don't find any.
Obligement.
Well, Mr. Doctor, Lordship,
Yes. This is a matter where the proceedings have continued and concluded, and they're waiting for the views of the APSC.
Yes, Lordship, APSC is examining the matter and sought for the legal opinion from us also. We have tendered our legal opinion last week. They will probably this week, they will change.
We'll keep it.
After 10 days, within 10 days, they will change, Lordship.
All right, then we'll list the matter on 23rd.
or your Lordship will give us further 2 weeks time thereafter, my lord. We can then conclude the matter.
Right.
Lordship fixes it after 3 weeks. If they send us the views or in 1 week, we'll have to take 2 further weeks time.
You inform the court what is the status on 23rd. We'll do that.
My lord.
Based on 23rd.
Very well.
Mr. P.P. Doctor, for the APSC requested by the court to apprise the court with respect of the opinion, if any, rendered by APSC on the order passed by the disciplinary authority. If the proceedings initiated and concluded against the defendant, if this information is to the court on next date 6/23rd.
Views sought, my lord. As per the views sought by the department.
As per the views sought by the department.
Grateful. my lord.
Views of the APSC as sought by the department.
Right, Mr. Law. Last time I instruction sought from Mr. Roy, my lord. My lord, I have seen the notification, my lord. Lordship, can it be on next Friday, my lord? In the meantime, I will go through and intimate my client, my lord. The ex-provider. Yes, next Friday.
We take the matter again on 20.
Development. Right.
Ese que es no recuerdo. Really pensamos, although lo sé que the fact that he had 2 wives. Let's say after that there is an order by the district judge to bifurcate 60% of the family person to the first wife, 40% to the second wife, like that. Lordship. That's okay. Lordship. After that they were required to provide some documents. They have provided by seeking some time. Subsequently they have provided. But thing is that in the last this thing,
the documents they have provided, we found some defaults also in the document. The documents submitted by the officer have been examined by the GC Mukhammadar and found that same are not in the light of the document mentioned in the list. And we have already communicated that part to the legal heirs of the case lordship. And in the meantime, lordship, as the family pension, DCRG, yes, everything has been this thing pending. The gratuity has been released very recently, lordship, still amounting to rupees 4 lakh something. And others, family pension and the DCRG, those are still pending, and they are required to submit some of the documents, lordship. The documents that are required to provide to us, we have already submitted to them. So,
Lordship, my senior is in league code number 18, Lordship. We pass it also the timing, Lordship.
You'll have it on. It's not 20. June.
God bless you.
also, Lordship.
May I please your lordship? Lordship, Mr. P9 is on lake. Sometime may be allowed.
Time being.
Approve only.
God bless you.
45.
Lordship, please. The directions we've already complied, my lord, but the declaration.
Lordship, we have also. Hello. Excuse me.
Good. I think
This is actually regarding to certain kind of LDs that has been imposed, which is in dollars, so that the rates are quite high. The amount is much more than what has been calculated. So, and that's the reason I think.
what about you? You have also received.
Yes, Lord. That's right.
Petitioner.
Yes.
This is Murari for you.
Yes, ma'am.
And yes.
J.R. Midha,
J.R. Midha.
retired, on Delhi High Court.
You have the full name?
Yes. Earlier.
Reply.
No. J.R.
Here we have of that of Delhi High Court.
Retired.
Right. Okay. I think you. And yeah.
Yeah, great. Date, in fact, I tried to speak to the person secretary to find out if any date. My lord may say 2 weeks at least, because I'll have to find out whether his availability.
It appeared
3 weeks, man. That'll be good, because July they may not be here till the vacation period in Delhi.
4 weeks.
Yes, sir.
From
That will be better.
The date of the thing.
Yes, ma'am. Grateful, great. Extremely great. Great.
Please, your lordship. On last occasion, lordship heard this matter and asked me to file my, submit my judgments, lordship. This is regarding family pension to minor child to the second wife, lordship.
This is regarding the family pension of the petitioner, not mine.
Petitioner is the mother of the child.
You're the second wife.
I'm the second. I have a minor child, lordship.
Nature is not before lordship. Only the second wife is with your lordship.
Yes, she has annexed the birth certificate of her son, lordship. A statement is there, the
He
both
will
of us
continue to receive till the age of 18.
18. Only
How
he
old
is
is he now?
9-year-old lordship, only 9 years he will get for survival, lordship. These are the judgments, lordship. To detail. There is the Supreme Court judgment, lordship. Following that judgment, this Honorable High Court also passed this order. The child of the second wife also, entitled for his part of family pension, lordship. Rameshwar Devi, lordship, Supreme Court, para number 14 is there, lordship. Here also mothers were before this honorable court. The minor children entitlement was satisfied by, justified by the honorable apex court, lordship. Thereafter, this court, our division bench also, lordship.
Para number?
14. Rameshwar Devi, para number 14.
So in division bench order.
Oh, lordship, para number. Lordship, 16 and 17, last page. Para 4. Page 4, 16 and 17. Then, lordship, there is another judgment of this honorable court regarding that entitlement of the minor child, lordship. Only 9 years he will get.
Para.
Lordship. Lordship, para 5, lordship. Para 5, page 2. Then again, lordship, one of the single judge of our high court, following the judgment of Rameshwari Devi, lordship, Supreme Court judgment, passed order, lordship.
Paragraph.
Paragraph, lordship. Para 10, 11, last paras, lordship.
What about the full bench judgment?
Full bench judgment, lordship.
Bench judgment.
Lordship. And prior to death of the husband of the petitioner, lordship.
It's a full bench judgment.
Lordship.
Right up. We'll dispose of this matter at the second half.
Lordship.
Bring the judgment. Full bench wala judgment. file my. We'll follow up in the second half again, after the end of the list.
Lord.
You get the judgment, we'll dispose of.
Please.
Lordship, it will be taken up tomorrow. My right in the meantime, I will also go to the.
Why tomorrow? Tomorrow is a Saturday by.
I'm sorry, my Monday.
So let us have it today. If you can't find it, we'll find it for you.
I have.
Let it come in the second.
Lordship. Lordship, Miss M. Bhattacharjee will be appearing in this matter, Lordship. It may be taken up after some time, Lordship. She's on legs in another court.
What is the matter about?
Yes, Lordship, the government, my lord, formulated certain parameters for appointment of my lord. District was my lord, video, my lord.
After some time.
My lord, I'm submitting, my lord. After a week, it may be directed to be listed, my lord. My lord, Village Defense Organization Act 1966 was enacted, Lordship. Under that, my lord, a rule has been framed, my lord.
You want
That
it
is
after 1 week?
Yes, Lordship, that may be big, Lordship.
The request to pick up. But we set up. Sharma, if you- after 1 week.
My lord, that may be
20.
Lordship. Of life.
Oh, it will not be 20, sorry. After 1 week, would be, let us say 25th.
Lordship. Life. Matter pertains to promotion, my lord, and non-communication of ACR. My lord, the respondents say that we have not communicated, but then they say that there's nothing at first. But then my issue is that, my lord, even if it is good, my lord, if I'm not meeting the benchmark, even that good is adverse, my lord.
What is the benchmark required?
It's high average, right? High average.
The benchmark.
Above average. Above average. Benchmark is above average. I got high average. So they say, my lord, at least 38 of the affidavit that
Above average is higher than high average.
my lord. Case 58, my lord, of the affidavit, my lord. The average is 5 points and above average is 7 points.
Readings are complete.
My lord.
Yes, Mr. Eddy.
Finish complete, my lord. Nothing, my lord, small. This, my lord, this jurisdiction point, my lord, is Manipur High Court.
Manipur. You are stationed in Manipur.
This, everything is Manipur, my lord.
Then why here?
No, that particular communication, my lord, was pertaining probably at he is from Manipur, my lord.
Where is that communication?
That
You're both, you are a member of Assam Rifle.
Assam Rifle annexed 2, my lord, is my lord, is notice, my lord, advocate notice. Because of it. Yeah. Phase 3, my lord, the name of the petitioner, my lord. Phase 3 name of the petitioner, my lord. This 42 Assam Rifle is Manipur, my lord. And his other respondent, my lord, New Delhi, Assam Rifle, Shillong, my lord, and 42 Assam Rifle is Manipur, my lord.
Have you raised this objection?
Not in my affidavit, not my.
That?
Yes, that is true.
If not raised, that's not raised. Why are you raising it now?
It is the present station, my lord. Yes, so the
He is
ACR
the
pertains to, my lord, the
he is
earlier
the
period, my lord.
president of which way?
Residence is the given, my lord, the 42, my lord, my lord.
Residence is of Silsar, madam.
It is not.
Sinha is not that Manipur is enough. It's Supriya Sinha.
It's just the my lord is put at 42, my lord. Page 3, my lord. 42 Assam record. It is page 3, my lord.
You're referring to page 40,
Page 3, my lord.
page 3.
Petition address, my lord.
Yes, page 3.
Petition address, my lord.
Presently serving as 42 Assam, right?
And page 13 also, my lord, he is activity.
But he belongs to Assam.
42 Assam was in Manipur, man.
He is very, is he a resident of Assam or Manipur?
He is a resident.
By birth.
Well, it is
By
affidavit, my lord. Affidavit speaks, my lord, is same thing, my lord.
I have to give my unit only, my lord.
Affidavit speaks. And my
In
lord
that
is
case, my lord, where part of
paragraph.
action has arisen, I have to clarify to an affidavit, my lord, if this objection is raised at this.
so this is not in the affidavit.
My lord.
So what do you say with regard to the merit of the case?
I will file affidavit on that may be, my lord, because everything is clear in affidavit, my lord. There is
Everything is
38.
clear, but we are asking you that whether in the
Even we communicate, my lord, the same thing will happen, my lord. This thing is 38, my lord.
So if they communicate, I get a right
you
to represent.
communicate that in terms of that without communicating.
That is true, my lord. I understand, my lord. But even that, my lord, the same thing will happen.
Communicate, he has the right to.
That is true, my lord. That is true, my lord. But same thing will happen, my lord, is because this whatever.
So the decision is already taken, my lord, before I represent.
I understand, my lord. And that is yes, I understand that cover, my lord. But thing is that, my lord, is super, my lord, even that, my lord, is jurisdiction point will not taken, my lord, but he is, my lord, residence of his present residence as per this residence of Manipur, my lord.
Now you tell me the point of jurisdiction. Where does the territory, how do you decide territory? For the
Well, petitioner should be or the restaurant, both should be within the division of this honorable court, my lord. But the petitioner himself stated in paragraph and his address as well as affidavit, my lord. 42 Assam record. This 42 Assam is from Manipur, my lord. And
Why
the,
not
all respondents, my lord, the 1, 2, 3.
Why not in Shillong? Because Assam Rifles headquarters.
Yes, well, Shillong also, my lord, is nowadays separate high court.
Why not in Shillong?
Yes, ma'am.
You raise the picture.
Yes, ma'am. Yes, sir. That is true, man. But I not in affidavit, ma'am.
So it's not there. Then why are you submitting?
I will file. We'll file an additional affidavit in this regard.
All right. Mr. Deepak. Okay. Due to the fact that take the that okay. Web. That is accept the ticket ability file. If by there may be
Well,
51 also, my lord, pleadings is complete, my lord.
readings complete.
My lord.
This is what
This was, my lord, a rejection in the stage of, my lord, selection only on the ground of, my lord, medical fitness.
Yes.
Lordship, he was found unfit during the detailed medical examination. It was deviated nasal septum. The deviation of the nose wall, Lordship, it obstructs his airways, Lordship. And as per the
There is a list of deficiencies, medical deficiencies, which
yes, Lordship, at page 53, Lordship, this is the guideline for recruitment medical examination in Central Armed Forces. It is in page 57, Lordship. C. 1 DNS 1 DNS. This is the DNS. DNS atrophic rhinitis, tubercular ulceration, chronic sinusitis are required to be excluded.
That medical finding, of course, my lord, is a thing of expert. Only thing that we had asked is that, my lord, whether we can appeal. The lordship has also indicated in the previous order probably that whether there is a provision for appeal. I could find, my lord, from the Ministry of Home Affairs website, my lord, this clause 8.5, my lord, gives the right of appeal. And this probably follows the normal logic that if there is a wrong, there always has to be a right of, my lord, representation. It's a different thing that the representation may not be considered on merits. Then the right of appeal, my lord, probably would be there.
Medical also it is confirmed at page 45.
Because we had cited some other precedents also that this honorable court in other occasions also had asked the re-examination.
where is that?
Copy.
Where is the appeal provision?
My lord, the 8.5. 5, my lord. Medical examination is 8.
This is for recruitment is which?
My lord, this is a revised scheme for common recruitment of constables GT in Central Paramilitary Forces, Assam Rifles, NSD, NIA.
You applied for which?
Warrant officer.
Warrant officer where?
Warrant officer.
In Assam Rifles.
Assam Rifle. Okay, as per my instruction, there is no provision of appeal, Lordship. It is from the.
Through this is a revised scheme, Government of India Home Ministry.
I'll furnish a copy.
You go through, we'll come back at 2 p.m. Let's find out. You go through it. Let us know at 2 p.m. If there is a provision for appeal, we'll close it. Getting him to file an appeal.
Next week, will be taken. Lordship. I think.
No, well, nahi hoता. Yeah, no,
Let her be listed next
yeah,
week.
instruction को ना. Next.
To be listed next week. Or What 18? Enabling the other CTC, the instruction, as to whether an appeal for the higher authority will get to the protection of candidates. Selection, rejection of candidates during the recruitment of constable officers in Central Armed Forces, including Assam. This is Assam Rifle.
Well,
Assam Rifle. As per Government of India, Ministry of Home Affairs, it's put by the Government Council. Copy of the same notification also been shared with the see get this instruction in place before 18.
I also it is possible, Lordship. It's taken.
18.
Lordship.
52, my lord, I have received the affidavit in opposition. We need to file a short reply, my lord. This is pertaining to promotion.
The Patak breathing time. Yeah. filed by the respondent. with after
Problem.
In matter parting regarding selection and appointment of Dr. Gaurav Himala. The reporting of Borpata issue advertisement, I was selected, my lord.
They have filed an affidavit.
They file affidavit, my lord.
Are you filing any rejoinder? No.
My lord, the rejoinder is not required because the main factor is that, my lord, he is not qualified, my lord. My lord, my humble submission that, my lord, the
Not qualified. Respondent 6.
respondent number 6, my lord, he is not eligible, my lord. He is not matriculate, my lord. As come that advertisement, my lord, at the time,
Now against the rejection, did you file an appeal?
yes, my lord, I submit, my lord. Then private respondent where I was selected, my lord, private respondent filed their writ petition before this honorable court. And this honorable court, my lord, was an stay order. We challenge this single bench order before the division bench, my lord. Division bench set aside the single order and we this operation of the petitioner selection on the basis of the division bench order, we are appointed, my lord, we join, my lord. In Vinton, appeal was pending, my lord. Now appeal was dismissed on the ground that I have no land in my name, my lord. But my question is that, my lord, my father have land. The petitioner as well respondent both are the brothers, my lord. And he is not eligible, my lord. He cannot challenge my appointment, my lord. At the time when he was advertisement issued, my lord, the private respondent was not matriculate, my lord. He admitted, my lord, the private respondent filed the affidavit.
Land is in whose name? His name.
Yes, my lord.
Your father's land is in his name.
My lord, he also my brother, my lord. Own brother, my lord. He has no land, my lord. He also no land, my lord.
You do one thing. Go to mediation, sort this out.
My lord, my humble submission, my lord.
My lord, and today in there will be considered at the returnable day, my lord.
Huh?
And returnable day in there will be considered.
Not interim prayer. You
My lord,
sort out before the mediation. You
my
are
lord,
thinking
in
over
prayer, I was selected, my lord. I was appointed, my lord. On the appeal order, my lord, my appointment was cancelled, my lord.
My lord, appointment was cancelled on the ground, my lord. He has no land property as per clause 7 of the advertisement, my lord. And by mislead the office, my lord. No, father is alive, my lord, showing father is expired. And his name was mutated for the application of that Gaugura post, my lord. While, my lord, it came to knowledge of the my lord, office, they have immediately, my lord, cancelled that mutation. Now the complaint was filed before the my lord, commissioner, and commissioner found that he has no sufficient land. I am also disqualified, but I have no my lord, objection. I am not praying for appointment, my lord. Now the selection process and my lord, that appointment already has been set aside. My learned friend has no ground to challenge that set aside appointment, my lord. Because he has no qualification, my lord. It will be re-advertisement.
Where is the impugned order?
My lord,
Impugned order, my lord, that finding is based, my lord, 48, my lord. 48 last paragraph, my lord. I am reading, my lord. Page 48 of the writ petition. On perusal of the Jamabandi, it was seen the name of the respondent numbers 5, that is present petitioner, have been strike off from the land record. Therefore, the report was sought from the office, Circle Officer Bagbor Revenue Circle. As per the report dated 27/1/2025, issued by the Circle Officer Bagbor Revenue Circle, it has been stated that as per the record and report of the LRA concerned, a plot of land measuring 21 biga, 1 kata, 13 lesa covered by the number Sonso, annual patta Sonso, Bilis Alopati Ansi, under Bagbor Moja was recorded in the name of Abul Hussain, that means the father, son of Sonso. Further, as per the order of Dadan Circle Officer, Bagbor dated 23/5/2022, the land in question was mutated by right of the inheritance of the name of the, well, some persons here, Sanwar Hussain, last number, all are son of Abul Hussain. In the place of Abul Hussain, thereafter, the above order dated 23/5/2022, well, had been cancelled on 10/5/2023 by Dadan Circle Officer with the reason that the mutation dated 23/5/2022 was done by mistake and corrected as was done in the name of original Pattadar. the land again has gone to the original patadar, that is Abul Hussain. And my friend is the son of that Abul Hussain. Showed that my father is already expired.
No.
And under capacity of inheritance, his name was mutated. But when got the information, then immediately cancelled. Now he is a landless person.
My lord,
On that ground, my lord, his appointment is set aside, my lord. So I have no, my lord, prayer for to get the appointment. I am also not qualified, but I have not filed the, I have not challenged that set aside, my lord, order. So my lord, it will be fresh
my lord.
the advertisement now. And how he has no land, how he will apply it?
Yes, my lord, appellate of that. My lord, kindly see, my lord, the here, my lord, here the my learned counsel it says the my name. The mutation which is done, it was done by himself, my lord, because his name also here, my lord. The petitioner, respondent name is also here, my lord. His name also mutated, my lord.
Where is it?
My lord, kindly that part already written, my lord. Page 49, my lord.
So where is the mutation? Where is the
My lord, I have annexed, my lord. In my affidavit, my lord, I have annexed.
Both there, my name also, his name also, my lord.
But my name,
both are
without my knowledge.
And at that time, my lord, the private respondent in charge Gaura, my lord. So it was done by him, my lord.
My lord, my misleading the office, he inherited the name of all the family members, along with me and my other brother also. But we have no objection because we have not done it. He is affected now. When the mutation is cancelled, my learned friend is affected. We are not affected because we have not gone the office. We never visited the office. Only for getting that job, he has done this work, my lord.
My humble submission, when my mutation go, but mutation in the name of my father, automatically I will got.
My lord, in the name of father, he will not eligible to become a Gavura, my lord. Can you turn to the, my lord, affidavit, page, my lord, page 61, my lord. I have annexed the Jawamandi copy, my lord. The circle officer has written.
I have some
as
decision,
per,
my lord, when the
as per land record, Mr. Sanwar Hussain is not patadar of above mentioned land. He has no land, my lord.
Yes, I admitted that. But I have my father had.
How, my lord, a person has no land? As per advertisement column 7, my lord, without land property of that locality, the jurisdiction of that Gav Pradhan area, my lord, he cannot become the Gavura, my lord.
Where is the advertisement?
My lord, advertisement, page 25, my lord. And
advertisement.
Page 25.
Yes, my lord. Yes. Page 26, my lord, the repetition, column 7.
My humble submission, whether my fatherland, my fatherland, and the mutation at that time when mutated, my lord, the petition respondent was insert, my lord. He was done that. I have not done, and I am eligible, my lord. I am eligible, so respondent.
Tell us the status of the Jama. Is your name there or not there?
My lord, that time my name is not there, my lord. Not there, my lord.
If your name is not there, then you do not fit clause number 7.
My lord,
But 26.
my lord, when father have land, my lord.
When father have land.
Yes, my lord. It is automatically legal.
Why do you have to go for later illegally? Because automatically father or mother have land, it will automatically come by the process. If that is the principle of your father's land, your name has to be there. Either as a joint partner or he as a sole owner. I try to give an interpretation that your father has a land. Someday you may get a land. You may not get a land.
That is right, my lord.
Yes, but he showed that father is expired.
No, that was not done.
By misleading you a land. He may write a will and say that you are not entitled to get.
My lord, the mutation which is done, it was done by private respondent because at that time he is my elder brother, my lord.
Let us say it is done by him. But as on date, to admit that there is no land. We did it. If that is that do not satisfy clause 7. Now you have carried this advertisement to say that clause 7 is not maintained. That is not your way.
My lord, that is right, my lord, but at the same time, the private, where he is eligible, he is not eligible, how he can challenge myself?
I am not praying for job, man.
We indicate it's not
Therefore, I am not selected, man. I am not qualified. Therefore, I am not selected.
He cannot challenge, he is not eligible, he is not qualified, my lord, he cannot challenge my appointment, my lord.
My lord, my learned friend want to say whether I have no qualification, therefore I cannot file the complaint or objection. I didn't come to the court. I went to the commissioner and only I raised a complaint that who is the person who is already selected by fraudulently and showing my father is already expired. A living father showing me expired, my lord.
Who is done it?
And immediately, my lord, the land has been cancelled from his land. And the commissioner, my lord, rightly passed the order, my lord.
Where is the appellate order again?
Appellate order, my lord, that is page, my lord,
44, my lord.
page 44, but finding is page 49, my lord. It is start from 48, the finding. Only on that ground cancel. He has no land.
It was filed by you.
My lord, yes, sir. But it was not my prayer, my lord, that though I am not qualified, even I may be appointed, my lord. Only his disqualification part I disclosed.
Then left.
And executing instruction, there is no provision for the person who have land. Here the only three guideline, my lord, only three factors are only three factors considered, my lord. And the division bench also, my lord, some decision, my lord, the land, it is not a factor, my lord. But in the advertisement it was mentioned, my lord.
Certain notifications are there. Maybe it's not there.
Oh.
Is there any change in the appellate?
Appellate order is there. Last one, last.
First one.
Last.
Last.
1 to 2024. There is a 162C against the order of appeal. A review can be filed.
It was below.
Who is Ikramul Hussain?
My lord, the present.
You are the respondent.
Yes.
You are Ikramul Hussain.
I am Ikramul Hussain. We are both brother, my lord, admitted fact. But now I am saying, my lord, that he is not, he has no qualification, my lord. He is qualified person holding the post, and the rightly order has been passed, and fresh advertise may be, and if he qualify, my lord, again he will appear.
Yes. But finally, it is given on back on the order. Have you challenged the order of the circle officer?
It was not.
Close the bit.
But the immediate fact, my lord, the land is my father, my lord.
That interpretation will not work. Or the writ petition is signed with the dispute order dated March 20. Or the director of land records, Arvind, in appeal number 121 by the order dated March. So the gist of the matter is that the petitioner applied for and in response to advertisement number 7 for election and appointment the Gampura, which was that district, which
Borpata, my lord. Lot
Where-
number 17.
Huh?
Lot number 17, lot number 1 and 2,
where is
Alavati
the
non.
advertisement
Page 25.
applied for lot number, which lot?
Lot number 1, 2, Alavati non ke, my lord.
Huh?
1 and 2, Alavati non ke.
1 and 2.
1 and 2, Alavati non ke. Is lot number.
No, in page number 25. Very good. Lord. Page 25.
Yes. 17 charge, lot number 1 and 2.
Charge number 17.
17 charge.
17.
Yes, my lord.
Charge number 17. Lot number 1 and 2. The Pagpur, the Pagpur Revenue Circle in the district of amongst the qualifications, eligibility criteria prescribed. One of the criteria prescribed is that the candidate should have landed property / movable property either when he or she intends to be appointed. Now, pursuant to the selection process undertaken, the commissioner was listed and appointed for the Article 17 for Munda for Rajab. His appointment, however, was challenged by the private respondent by filing WPG 113. This quoted date of this court by order dated 1/3/2023. While granted an entry order that the disposed of the writ petition in view of the averment made for the court, in view of the submission made before the court that the petitioner had also prepared a plea. Petitioner in WPC 1148 of 2020 had also prepared a plea before the respondent of reassailing the selection of respondent 6 appointment. The petition was disposed of that the appeal should be considered as resolved by respondent within not later than 8 weeks. And until such an appeal is disposed of, no order of appointment is to be issued in favor of the respondent number 6 therein, namely petitioner hearing. Petitioner being agreed, preferred writ appeal 119. The appeal court by order dated 4/23. modified the interim order granted, permitted the petitioner hearing join post after direction to be considered towards disposal of the appeal by the but not in the money. So subsequently, the appeal came to be disposed of now that the split authority part here. The appellate authority by the appeal passed an order disposed of the appeal heard by the private respondent, rejecting the claim of the private the appointment after you the private respondent with the educational quality date when the he had submitted his at the time of submission of his application for appointment. So, the appellate authority also careful examination of the materials available, including the report, the concerned settle of returned a finding that the land which was stated to have been mutated in the name of the petitioner and the private respondent and their other sibling was done by mistake. Certain officer and cancelled the order, said order on 10/5. Consequently, no land is mutated in the name of either the petitioner or the private respondent. The such circumstance, the appellate authority right that the respondent is also not qualified towards the appointment. He should post to counter review for non-fulfillment of clause 7, i.e., that there is no land holding name of the private respondent in the name of the present the appointment petition. The reading it's said that the respondent 5, respondent 6 has filed his affidavit of taking the then account the party the third accountant for the daily has submitted that the appeal order needs to be interfered with as the no that the simply and the dad the name of your father. What's the name of your father?
Abul Yusuf.
Right. And it's their the legitimate children said and their father the children of the man. There is a you stay with your father.
Yes,
or separately.
no. My father live with me, ma'am.
You have to be firm and the condition 7 the and cannot be person apply what is required that person and frequently has some clarity. There is a strong possibility that there is every possibility that after defining other part of the land is all by merit and at present right of other the respond, private respond, the other end, no interpreting as the order of debate issued by the federal or cancel by operating and as of date that order is held that the other council that are the other end of the permit the agreement and the authority that passed on by the relevant materials available. There are having heard from that in the application itself, there are several materials that by it by getting specify the requirement for and they did not have none of the conditions including all which shall be accepted by the circle officer by order dated had cancelled in a year by the day of and simply being like and the date is ordered it's a very the page of even for heaven not for at this stage you fact that there is no ambiguity of this pattern gadget the debate of that apart these houses have state calling on smoke hatred heads of subsequent mind public data when public there oil of very also see from the amendment that regulated that under both parts B
D. Reviewable.
if advice take reports clause 1C. But art definition that is like this was order if you was.
The judgment.
The same clause.
Same clause, sorry, same clause.
Same clause.
With the arbitrator agreed upon.
Lordship, from the list, Lordship may give.
Justice Chayarani Goswami, retired district judge,
Otherwise, I pay for from the list, Lordship, as per Lordship service.
is from the list, Lordship, retired district judge. Lordship. Lordship 24, Tuesday, 24. Tuesday.
My lord, may I reflect paragraph 6 of that particular order in this order, Lordship.
Yes.
Paragraph 6. Lordship. Lordship. Lordship.
Deeply. And the last order.
P. Nayak is appearing in this case. I'll inform him, my lord. I'm not in the case, my lord. P. Nayak is appearing.
No, we had adopted, deferred it. Yeah,
Lord.
we are informed that we don't take. Required parties have instructed.
Lord.
Where is the coagulated port?
No, case 70.
So in your case, there was a review order passed in terms of the direction.
My lord, the direction was given, my lord, to pass a review order, revision order, my lord, in pursuant to this OM, my lord, as well as, my lord, that, my lord, mandate of the Honorable Supreme Court, my lord. But subsequently, my lord, that 15/6/2023 order has been passed, my lord. My lord, my case is that, my lord, it is not a revision order, my lord. My lord, they have expressed their inability that relevant files are not, my lord, in their possession because, my lord, all the files has been, my lord, seized by the Chief Minister Vigilance Cell. So they are not in a position to proceed the departmental proceeding. That's why, my lord, that it is deferred until further order. Suspension order has also been, my lord, extended until further order. And, my lord, subsequently, my lord, a new show cause has been issued, my lord, supplementary show cause without, my lord, without, my lord, statement of allegation, no list of witnesses, no list of documents, my lord.
Did you file any application
My lord.
for when the
No, my lord, we have filed, my lord, for my lord, inspection of relevant documents, my lord.
Nothing has been done.
But not, my lord, they have expressed their inability, my lord. So, my lord, in a more casual manner, my lord, that proceeding is going on, my lord. My lord, as per OM, my lord, 4/2/2020 also, my lord, the periodic review is mandatory, my lord, in other words. Last paragraph.
Yes. The you may say the reasons are not sufficient. You may question the justiciability of the reason. But you cannot say that this is not a reason. It's an order, according to that, they have given reason. One line, whatever reason. You may challenge justiciability of the
No,
reason. Reasons are not sufficient for extension.
my lord, reason order must, my lord, should be, my lord, is a justifiable ground should be there, my lord. But my lord, they are not in a position, my lord, they are almost aware that, my lord, relevant files are not with them, my lord. And my lord, they are extending the suspension until further order, my lord. My lord, in my support, my lord, Honorable Supreme Court has also, my lord, held in several decisions that, my lord, reasons order must be baked for some, my lord, judicial down, my lord. As judicial order as well as, my lord, quasi-judicial order also.
The reason order, they have given the reason that department proceedings indicated investigations are going on, some relevant documents were taken by the concerned by.
My lord, and my lord, also kindly see the last fourth paragraph. In view of the above compelling facts and circumstances, the suspension period is extended and also departmental proceedings so become deferred until further order. My lord, they have expressed that the no periodic review will be made, my lord.
Yes. Yes.
So, my lord, total non-application of mine, my lord.
This PMC.
Actually, my senior was
That is what does the pre-class.
actually, I made a request for the matter to be taken at the end of the list.
We are approving the end of the matter. End of the day, take a the end of the
Yes. Much obliged. I have a full bench judgment.
Junupa.
Junufa, Musamma Junufa, para 19 and 20. Petitioner is the surviving widow.
What about the eldest wife?
He died not. She died not.
He expired.
She expired, and the son from their wedlock, he is a major one. Only the petitioner's minor son is the only son, minor son.
Where the petition, only the petitioner is the second wife. And the son, minor son is not made a party here. And the PI itself on the petitioner is to get the pension.
Son got it.
Yes,
Right,
Lordship.
my contention is that the minor son has not come before the court, only the second wife have come before the court.
Minor.
Man,
Statement
on the
is-
representative capacity, he can come. Only thing is that, man. As per the law, well, he is entitled. My minor son is entitled. That's the law.
To be direct,
No,
you have a bank account with the name of the minor.
Minor son, I do not have. Petitioner has, Lordship.
It's the name of the minor.
In the meantime, we will, she will, do the needful, Lordship.
my contention is the petitioner is not, being a second wife, petitioner is not entitled. Their law is
What
settled.
want her now? To keep the pension
Understand. The law is that when it can,
in the law.
No.
You're asking you what particular you require now.
well, they will approach the 30 minor. Details, what are the particulars they need. Well, that
With the details,
they will come with the along with the petition, the other details if required, they will furnish it, because some documents now it's all online.
certificate is there.
He
Birth
is there.
certificate is there. Other things have to be there. Age and everything, Till the measure, he will see
Certificate,
everything. If required, other things, they will communicate.
your name reflected in the document.
No.
No, Lord.
Department. You have not disputed the birth certificate yet.
No.
Birth
They have
certificate-
filed affidavit, Lordship. There
Birth
is no
certificate is not
dispute.
disputed, because the petitioner wants the pension. That is disputed. Petitioner is not entitled to pension. That I have said.
Are you questioning the birth certificate?
No. That not I'm not.
If
No, that I have.
you have not, accept that birth certificate and the care of pension.
Well, that can be done, my lord. Only thing is while processing some document, 30 minutes ask for some document. That's the thing, and ultimately it had to be on. That payment had to go online, my lord. That the account had number. Right now, I cannot say when in the processing all these things, my lord, some document may be required, and the account numbers is required.
Account number.
Hmm.
Fine.
She will provide account number. In the meantime, she will.
But any other document.
There is-
If any required, my lord, will communicate and
You can ask for a vague document. Cannot be.
no, vague document will not ask. Only that particular Aadhaar card and all these things have to be given, my lord. That may be one of the documents, because Aadhaar card will make it.
The name, the minor.
I know, and Aadhaar cards, that will make it clear, my lord, that everything will be there, my lord. Fingerprint, iris, or scam, all this will be there in the Aadhaar card, my lord.
You have
Aadhaar card, Aadhaar card.
They will have it, my
Aadhaar
lord.
card we will provide, Lordship. Aadhaar card, birth certificate we will provide, Lordship, and if bank the account is required, in the meantime we will do, Lordship. Let them release the pension. My share, minor son's share.
Not the petitioner.
petitioner it is till the year of the after death first wife.
When there is an agreement also for marriage.
She is the second wife, means she is the sole wife at the
So,
time of his death.
after the marriage took place during the existence of the first wife.
No, no.
After the death,
Lordship,
After
we
that-
came, no, Lordship, at the time of filing, we thought that we were the first, I was the first wife, but they came with the information that first wife died after our, after marriage of second wife.
that's
Actual-
my affidavit is absolutely clear, my lord. The son has also said that his first wife expired on 27, 2016. First wife expired on 27, 2016.
That date was not, we don't know the date of death of first wife, Lord. They came with it.
Because that wife expired after the death. First wife expired marriage with her late husband. It was not 9 years old.
And now he's 18/1/2015, he was born, Lord. Page number 21 is the birth certificate.
It was- okay.
Next to kin she has lordship. In that both the names are reflected. Page number 20.
Page number
20, lordship. At that point of time, son was 4 years old.
calculated of the death certificate. Like the birth certificate. Stop. The other
Bank account details also next to this court petition, lordship. Page number 31 of the petitioner, mother, guardian. Page number 31.
they could be joint account.
Joint account, lordship, of father and mother.
Do you have any regulation?
There is a regulation, my lord. 2014.
Like family pension rules, Lordship, I have given that. That was supplied on last.
The record itself, my lord, it comes, it is the rule 57 in program.
54 and 57, Lordship.
57.
57 of the regulation.
No,
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 Lordship,
that-
that regulation I have
Regulation,
given
my lord.
last.
What in municipal corporation employees, we can take a
If
pension regulation.
I can give another copy. This is my.
It's like considered joint petition. Petition and not decide. And son. Went up. Here. Mr.
Miss Paridevi, para 14, Lordship, relevant.
Middle chocolate of the or going to forget. Seven. Wait. Let's see that right and there the content the I think yeah. Responded however that minors are. Oh, information that order with it does. Okay.
This is a regulation, my lord, 2015.
Yeah, right. Get it. Right. Yeah. Second. Right. Right. You're not seeking pension for the wife.
Petition both, I am saying that I am and me, myself and my son, both are suffering lordship, and prayer is also to release the family pension to me. I mean, I am the guardian of the minor son also, Lord.
Have you seen the regulation?
Yes, Lord. Wife.
Regulation says wife.
Wife.
How do you suppose you
Surviving wife. I'm the surviving wife, Lord. First wife died, Lordship. That is the
know that? But whether your marriage put before the authority, your name included in the document.
no, that is not there.
Yeah.
In that case, minor son is entitled, Lordship.
But we are asking you,
Yes.
what is your prayer?
No, minor son,
Only
share
minor
of,
son.
only share of
We are recording that.
Lordship.
Therefore, we are asking. Are you pressing that?
Minor son's share may be given.
There is a 18, my lord.
Yes, that. Eligibility for-
আমি বেশি দিন না আমার কি আছে দিয়ে রেখো
But
Lord. Prior to death of her husband, Lordship, he nominated me. I mean, my husband, Lordship. My husband nominated my name. Recently she got this paper. That's why it's supplied to me. If it can help in any manner.
for you to decide.
Only.
For asking the court for legal advice.
No, Lordship. Minor sons. But I'm just saying that this is there, though. I mean.
That is why we repeatedly we are asking you, are you pressing for your prayer for the wife? You are saying, no, we are going for the minor son.
Minor son, Lordship.
Don't bring unnecessary people.
Lordship.
Public life. Right. Here. Oh, it was- Okay. That- 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 That's not right. Right. Okay. Very, very. Right. Open.
Deeply obliged. They will survive lordship. Condition is too bad, the families have.
Do you have a copy of this?
I-
Lordship, you can.
Lordship, I have
You can
my
take.
copy.
We keep it.
Lordship, deeply obliged.
Great pleasure, Lordship. Lordship, this matter relates to compassionate appointment. On the earlier occasion, I had
Here.
on the earlier occasion, my lord, I have placed one order of the coordinate bench of this honorable court, my lord, whereby similarly situated cases were decided. So in the light of that order, my lord, my case may also disposed of, my lord. Direct,
Have you challenged the OM?
no, my lord, but OM is after filing of this writ petition, my lord.
The judgment, if you look into paragraph 2, first line,
My lord, this OM was issued after filing of my writ petition.
therefore, this judgment does not cover your case. These petitions have questioned that OM. Therefore, this order was passed.
I think, my lord, para 10 of the judgment will cover my case.
So your para 10 will have to be understood in terms of the nature of the case.
Yes,
There is a clear finding of the court that these writ petitions have challenged the OM. Your case is that your case has been rejected by
SLC.
SLC.
Yes.
On what ground?
On ground of non-availability of vacancy.
Non-available.
Yes.
So you want a reconsideration.
Yes, my lord. That much fair only I have.
But reconsideration cannot be done in view of the 18/9/24 notification.
Yes.
That notification you have not carried in the presentation.
If the judgment doesn't cover my case, I would like to submit further on this case, my lord.
Please.
Now, the case of the petitioner is that, my lord, the petitioner's father, while working as a diver, my lord, he died on 3/8/2009, and petitioner fought several round of litigation, my lord. Thereafter, my lord, on the earlier round of litigation, my lord, page 16, my lord, kindly peruse, the order dated 11/4/2018, my lord. In this order, my lord, last para of the 16th page, my lord, after considering the materials available on record as well as the communication dated 28/11/2016, it appears that the SLC has considered the case of the petitioner for the vacancies arising in the year 2015, my lord, where the direction was, my lord, to consider his case against the vacancies recommended in the year 2009 and 10, my lord. This was the particular direction given in the earlier round of litigation. But SLC at present has rejected the claim of the petitioner on the same ground, my lord. They have rejected the case and recommended against the vacancies of 2015. So this order was also not complied by the respondent, by the SLC. For that, my lord, only I am praying for reconsideration in my matter. This earlier order was not followed. It was partly followed. If lordship will peruse the order dated 26/9/23, my lord, in this matter, my lord, earlier order, it will be clear, my lord. And some records are also called for, my lord, for verifying such claim.
You show us the SLC order. Which order you are challenging? Page number 18.
Page number 18, yes, my lord.
Where is the
Column 1, my lord.
where is the finding as per your concern? Where is your case considered?
My lord, paragraph 2, paragraph 1, my lord. Contempt, page 18, paragraph 1, my lord, column 1.
Okay.
Yes.
What happened to the contempt case?
Contempt case was closed after this order, my lord. SLC rejection, my lord. They say they have complied with the order. But it's not the complete compliance of the order, my lord. As this honorable court have directed the respondent to recommend against the vacancies that were arose in the year 2009 and 10. So my only prayer before your honor is that, my lord may direct the respondent to reconsider my case, my lord, against the vacancy that were arose in the year 2009 and 10. That is my humble prayer before you.
Yes. Who's appearing here?
Lordship, I am appearing for the government lordship. Response number 5 only. SLC is not a party here, lordship. Only the district commissioner is the party. They are challenging this SLC lordship, but SLC is not made a party lordship.
He's by the chief secretary.
Yes, lordship.
Tell us what is the direction of the court? Page 17.
Yes, lordship. The direction was it has been observed, lordship, in view of the matter is remanded back to the SLC to reconsider the case of the petitioner against the vacancies of 2009-10 as recommended by the DLC in the next immediate sitting, and thereafter pass appropriate orders in accordance with law. So accordingly, lordship, on 14/5/2020, lordship, the SLC took up the matter, lordship, and in starting from page 18, lordship, the matter has been taken. So page 19, lordship, I just want to refer, lordship. From second para, lordship. In after rejection in the SLC meeting held on so-and-so, Sri so-and-so approached the honorable court and filed writ petition number so-and-so and subsequently contempt proceeding number so-and-so, where honorable court has directed to reconsider the case in the next SLC meeting. Hence, the case was placed in this SLC meeting and discussed. But it was observed that the total cattle strength in that division was shown as 6 numbers. The committee examined the WEM of 1st June 2015, which says the following. In para 5 of the OM states, compassionate appointment is not a matter of right and it will be subject to fulfillment of all the conditions, including the availability of vacancy laid down for such appointments under the scheme. Further, the guidelines also clearly state in para 14A as follows. Compassionate appointments can be made up to a maximum of 5% of the total strength of the cadre, man in position in the cadre at the time of recruitment in any grade 3, not above the level of junior administrative assistant, so and so. Further, para 14A2 also states that in a cadre where less than 10 vacancies are to be filled by way of direct recruitment, and that in terms of cadre strength or man in position, one or more posts falls short to reach the 5% level of compassionate appointment. The appointing recruiting authority, if so, considers that giving any post at that stage for compassionate appointment would jeopardize the purpose of recruitment, she may not consider for giving any post for compassionate appointment immediately and issue a speaking order for doing so. It was the unanimous view of the committee that since the total cadre strength of his position in the division was only 6 numbers, giving any post at this stage to the candidate would jeopardize the purpose of recruitment as the cadre strength of the division was so small, and unanimously decided to reject his application for compassionate appointment in light of para 14A and para 14A 2 of the above mentioned OM. So this was
These 6 numbers are vacancies relating to which year?
6. Cadre strength is 6, Lordship, not vacancy. It is the cadre strength.
Cadre strength.
Yes, Lordship. So compassionate appointment have to be of 5% of the cadre strength, Lordship.
Where is that notification again?
Pardon, Lordship?
That OM 15.
OM 15. OM 15, have you attached? No. They have not annexed this. And OM 15 actually, Lordship, is not applicable to that. In view of NC Sonto's judgment, Lordship, because admittedly the death was on 2009, Lordship. And subsequently, Lordship, the Debabrata Tiwari and observation of there are a number of writ petitions. This is their Lordship.
My only contention is that whether my case was recommended against the vacancies of the year 2009-10.
If the total cadre strength is 6, how the DLC recommended?
Yes, Lordship, only one vacant post was that this was not meant for, cannot be meant for the compassionate appointment, Lordship.
Where is the DLC recommendation?
My lord, affidavit filed by the respondent number 5, my lord, is at page 6, my lord. Page 6.
Yes.
Page 6, column, bottom line, my lord. Number 1, my lord. Kamal Bora, late Boluram Bora, my lord. Recommended for the year 2009 and 10. There was a vacancy, my lord. His case was recommended for the year 2009 and 10. Whether that has been done by the respondents or not, that they may clarify.
Page 37, it shows that one vacancy is there.
Yes, ma'am.
Available for compassionate appointment.
But this is the department can clarify, Lordship.
You get it clarified.
Yes, Lordship. The department has to clarify on that
Who is
point.
the department?
PHE, Lordship.
Get it clarified.
They have to clarify.
After vacating.
What do you mean after vacate? There is an
I'll come
order
in
of the
instructions
court, you
when-
have to get the,
I have to get instructions.
so you get instructions. But there has to be some consideration with regard to directions of the court. It is an order of the court passed in page 3, where the direction was that you consider against vacancies of 2010. No appeal, no review. And SLC says there is only a cadre strength of 6, so therefore there can't be a vacancy.
Yes, come there against vacancy, Lordship. And here,
But
driver 1, grade 3, grade 4, both 1-1, and both are shown to be the compassionate ground, Lordship. The department has to clarify on that point, Lord.
so you have to tell us what is the cadence?
Yes, Lordship.
Page number 6 or what is
No, well, I have the minutes. I can directly communicate with them. Please. I have the minutes with me.
minutes are there, you get the records and find out.
Okay.
Get it from the executive engineer PhD Dorhat.
My lord.
Lordship.
Heard?
Tell it.
How the thinking
Exactly.
was specific, the important way, the truth of the restriction, demanding the matter back to the SLC, the case of the vacancies of 2009 as recommended by the DLC. They immediate next the SLC consider the case of the 14/5/2020. Right? So health and since the cadence break,
76 got like proposal.
there is a question of
Yeah.
reserving one for compulsion. Therefore, it's the cadence break was 6 for the revision. So, available. However, they do that of the minus of PLC. The minutes but minutes really repeat that it are the office of the executive engineer the vacancy position reflected it for the year 2009 one post driver grade 3 and grade 4 it is available for open. However, the total data strike has not been successful. We direct the planning PH obtain clarification of the executive slash executive engineer PH as to the vacancy position available for open for the year 2009-10 and as report 20 22 the right vacancy
Next slide.
20
Highly obliged, ma'am.
Lordship, time permission, I beg mention something, item number 5, my lordship pass order, my lord. I hurriedly came from hospital but missed the item, my lord. My name may kindly be shown if it is not signed. I have no objection, my lord. What type of order has been filed?
we are informed the matter is because the truck was therefore
My
name. Report here.
What?
I think we have reported the name.
I have no objection. What type of order has been passed by your lord? I didn't get any instruction also. But my name may kindly be shown. Much okay.
Fifty-five, my lords, we have obtained the records
I'd like to reiterate, my lords, the records were sent in original to the office of the senior government advocate way back in 2018. Still then we have retrieved a Xerox set. Will you kindly grant me some time to examine this? The bulky record. And it was a exercise of 2014. So basically his contention is that women reservation has been applied both horizontally and vertically. A second. Hold on. So I have to examine the record. If he has a case, we'll admit. But Lordship will also peruse the records, or Lordship will direct me to examine the record. I'll examine that. It needs some time, and such a bulky record.
You made it bulky.
No, it's recruitment exercise for a state, my lords.
Right?
16 will be
Then lordship may keep it as part because otherwise, if the matter goes to other than lordship, then different
What?
will come. So lordship may take a
No. That is something different, my lord.
No, lordship. My issue is simple, lordship. Lordship can dispose of it on the basis of my reputation itself. No record is necessary. Whether they have followed the lordship reservation policy or not, the state policy, lordship. They have whether lordship the
No, my lord.
that is the issue, lordship.
Private
What is their
respondents
issue?
are
I
there.
don't know, lordship. They have not stated in their affidavit what is their issue. But my simple issue.
That means that you can attend to the last.
Last week of June, lordship. Yes, last week of
My lords, after
that is-
vacation, my lord.
No, lordship. Before vacation only because it's 2016 matter, lordship.
No.
16
This is
matter.
23,
No,
my lord.
appointment
No.
2016.
In 16, he filed
First
a
round of
case.
litigation, lordship. It is the second round of
No.
litigation because of their fault on
My lord, in the first round, he was only asking
Yes.
for his copy, these records.
But that record will be given after 6 years. That is their issue.
Then, my lord, after vacation, my lords.
Before
My lordship,
vacation,
vacations are there. Lordship knows motion days are declared, my lords.
To provide me the
No, there is no direction. Where
There
is
is
it?
direction.
Where
See
is
the order.
No, there is no direction.
Lordship, kindly see the order dated, lordship. There is a direction to provide me the copies.
No.
They have not yet provided, lordship.
No, my lord.
They are just
There's-
strict order, lordship.
There is no direction.
Lordship, yes, I am
Order
the order,
dated?
lordship.
Asini.
Order dated, lordship will find 27.5.
No. 27.5 doesn't whisper anything like that.
I will read the order.
What to say? What to say?
Yes. Two orders are there, lordship.
27.5 order was communicated to us. He cannot be privy to this
Lordship, I get the
records, my
order.
lord. Records will be
Order-
examined only by the court.
27/1/2025, lordship.
No, one or two order. 27/1/15, 2025. Sure.
Yes.
Of the appointment order.
Yes, appointment, all order, appointments.
Appointment orders, but that doesn't say records. No, that doesn't say the entire records. He'll be provided only appointment letters of the private respondents, nothing else.
Not private respondent, all the appointment letter. Just you see
No, it says copy of the order of appointment, if so is,
yes,
shall be furnished.
yes. That has not been
For
provided,
the petition.
lordship.
We have once given him once, but I'll furnish him again, but not all the appointment letters he will get. He's assailing certain specific respondents are there. Certain, no.
Court order is copy of the appointment order.
Appointment order.
Is not specified.
Yes.
Appointment order, lordship. Yes, I'm seeing. All appointment lordship.
No.
141.
Specified
No.
the order.
Then lordship will interpret the order, lordship.
Why will I interpret order?
No, lordship, because
Court
all
orders are not to be interpreted. If you are agree, you will file a review.
lordship, there is the order to
Hey, order, we have the order, read it, 27/1.
lordship, that order.
We have it, you read it, we'll give it. Don't have it, read it. Whatever is expected, it should be.
Lordship, order is yes. Order is just to lordship provide me the appointment order.
Copy of the order of appointment, not order of appointments.
Whose appointment order they will provide us? Lordship,
You to clarify.
yes. Copy of appointment order is
Appointment, copy of order.
Right?
I'll be providing him with the appointment of those private respondents which you have arrayed as respondents. That will suffice.
Right.
He cannot be privy to all the records.
The public record, all of the right to support.
Go and file RTI.
Already filed. 6 years you have taken to provide me.
My lords, after vacation, my lords.
Before
My lords
vacation,
knows
before
the
teacher,
my lords, the pressure we feel, my lords, in the motion days, my lord.
Lordship feel the kind of.
Madam, motion days, Lordship knows the.
What are you challenging here?
He was not
Simple
appointed.
issue, Lordship. My challenge is that, Lordship, there are 141 appointment posts. They have, if Lordship go by the provision of the Apex Code that 50% of the first 50% on merit basis will be considered for open category. So out of
Challenging the appointment order to the respondent.
as well as the Lordship selection, minus of selection committee.
Minus of the selection.
Yes.
The respondent, the third copy,
Lordship notice was served long back, Lord.
they have
They have not.
They have not entered appearance. We have served to them also, us also, but they are not coming forth.
We'll have it on 15th July.
As a fixed matter, Lord.
The request made by Mr. Boy. Report the earlier it's placed.
Preconsul. We kept as Xerox with us.
That is the report by supply. Peruse the report. It is why it's here. Again, 15 to
The kind of appointment letter should be provided to me.
the respondent will also provide the appointment letters as indicated, ordered, dated,
I'll email him, my lord. He'll give me endorsement, my lord. Publish, my lord.
Published.
May it please your Lordship. Lordship, that is the last order is the 2005. I've got the confirmation.
Yes. I earlier ordered dated 05/2025. Justice David Sharma. That right. 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 Agreement. F. ID. Agreement. Contract agreement. Work. Disappointment. Learned counsel. Petitioner has submitted a written declaration without date.
Lordship, just issue thank you. He has given it yesterday, Lord.
No, you have to give a date.
No, it was issued by him, Lord, his Lordship, Lord.
Ask for a date. How can a letter be issued without a date? Or an email or something?
It was issued yesterday, Lordship.
Report that.
Lordship, I got my submission that it was.
See, there is a procedure prescribed. Follow it. It doesn't carry any meaning without any date. Who was appointed? Something has to be there. You received it without even checking it.
Okay.
Written declaration by expressing your acting the written declaration secretary it is per the it's put the site. Yeah, it will market will appear. Yeah, it is okay. It is order indicated by the right. That will be written declaration. It's
Yeah, can I just submit one thing? While handing over this declaration, also, he just expressed the view, his lordship has expressed the view that there's always some problem with payments from the railway side, lordship. He has expressed the view that at least some observation to that extent from the both sides will or some administrative.
between you to decide.
All right.
Data is not valid.
Lordship, again, in respect to item number 6 also today morning, also, same he has accepted it, he has expressed. I couldn't present at that time also because I was stuck in the traffic jam, lordship. I've asked the council to be here, lordship, and it's the same order.
If it is not signed, same arbitration.
Same arbitration. Again, lordship, the same order because there is no date in this also. It was issued yesterday, lordship.
Copy of the written declaration. It's because the court. Yep. It's good.
Highly open.
The present petitioner was, while working as LDA, he was suspended from service with a charge that he has involved in issuance of some fake certificates in favor of some persons against whom numerous cases were pending. And that was the incident of since started from 8th of August 2019. Thereafter, my lord, he was taken into custody, and after 1 month of detention, he was released on bail, and subsequently, his suspension was continued, and by interference of this honorable court, he was again reinstated in service with a direction to conduct any disciplinary proceeding if required by the authority concerned. That in pursuant to order of this honorable court, disciplinary proceeding has been initiated by issuance of show cause notice dated
You are challenging the termination order.
dismissal order.
Dismissal order.
Yes.
As well as the order of the appellate.
Yes. Now, my lord, in pursuant to order of this honorable court, a disciplinary proceeding was initiated by issuing a show cause notice dated 13th April 22, which your lordship will find.
The no objections are filed.
No, lordship. Actually, rule was issued, we received, but it was not filed, lordship, someone.
Show cause notice was your lordship will find at page 52.
We can permit to file it.
Lordship, if your lordship kindly allows, then it will be.
I think better to have a counter affidavit of the respondent.
Yeah.
The records are also
Yes, Lord. That was correct.
expedite the hearing.
Lordship. If possible, lordship, I shall file it before the vacation, lordship.
Week?
2 weeks, we'll file. We'll file,
Kindly
lordship.
fix a date after vacation. sorry, yeah.
So, like,
22nd, Lordship.
Okay.
Lordship.
And rejoinder, if they find,
Yes, sir. Deeply obliged, Lord.
Disposal.
what is the thing? Very
Lordship, that instruction awaiting law. That I have already communicated. Yesterday I reminded also Lord. Just I'm praying for 1 day time, Lord.
you bring for 1 day.
Yes, Lord. Tomorrow evening. Tomorrow. I mean Monday, Lord.
Click on next Tuesday, my lord.
Tuesday. They request me like, their prayer have been made in the morning instead of.
I'm very sorry, Lord. It went out of my head, Lord. I'm very sorry.